Well, welcome to this really exciting session with the Honourable Michael Kirby AC CMG, in which we will be discussing the theme of working for global human rights through civil society and UN agencies. And it's my great pleasure to hand over to Auntie Malara to give us a welcome acknowledgement to country. Thank you, Auntie Malara.
Thank you for the opportunity. So I call on all of your ancestors, all of your sacred ones, of all your lineages, from all the lands across the ocean. And for those who are born on this land, we welcome you. We call on your ancestors as I call on my ancestors and the ancestors of this land to welcome you proper way, to know that you have a place here, a sense of belonging, and that we look forward to welcoming a partnership as we move strongly into the new dreaming. We thank the ancestors, past and present, and we look forward to the emerging leaders of all nations to work together. May each of you feel blessed, protected, as you journey together with us in partnership into the new dreaming as we walk together. I welcome you to this country. Nanga.
Well, thank you so much, Auntie Malara, for that extremely profound welcome. It's such an exciting opportunity to have with us such a legend of the Australian law. Of course, he'll be no stranger to any of you, but when he retired from the High Court of Australia in February 2009, Michael Kirby was Australia's longest-serving judge. He was first appointed in 1975 as Deputy President of the Australian Conciliation and Arbitration Commission, and soon after he became inaugural Chairman of the Australian Law Reform Commission. Later, he was appointed as a Judge of the Federal Court of Australia, then President of the New South Wales Court of Appeal, and concurrently President of the Court of Appeal of the Solomon Islands, which of course is a country that features prominently in our discussions this week. His appointment to the High Court of Australia followed in 1996, and he served 13 years. He also served on many national and international bodies as a member of the World Health Organization's Global Commission on AIDS from 1988 to 92, as President of the International Commission of Jurists from 1995 to 1998, and as UN Special Representative for Human Rights in Cambodia from 1993 to 1996. So many other appointments that I'll have to spend the whole session referring to them all if I speak to each one of them. But I would also like to highlight for today's purposes his work as chairperson of the UN Commission of Inquiry on Human Rights in North Korea, and also his current role as co-chair of the Human Rights Institute for the International Bar Association. So it's Michael Kirby, it's a great pleasure to welcome you to this virtual classroom.
Thank you very much, Professor Farrall, and my respects to Auntie Malara for that wonderful welcome to country, which is an inspiring way with which we will find our journey into international activities, so far as I have been acquainted with them, and there have been a lot of them, and they've been in different areas and by different means, and so my life is a kind of example of how, if you have a bit of luck and you have a lot of energy, you can contribute to building the better world that Auntie Malara mentioned is our human obligation. So we're going to have a conversation and then at the end of it, I hope there will be time for some Q&A, because that's the way knowledge is shared. So you have some questions for me, first of all, I think, Jeremy.
I've got a number of questions to put to you. And the first one is, how did you first become interested in human rights?
I was born in 1939 and therefore my first unconscious years were during the Second World War, and my conscious years began when I was a child student at the local public school. All my education was in the wonderful public education system in New South Wales, where I learned very good values from the teachers. And so the coinciding with those earliest years in school was the establishment of the United Nations. And therefore, it was quite exciting that the war in which so much sacrifice had occurred and that even children knew about was coming to an end, and in its place, the world was building this new organization. I remember when I first saw the symbol of the United Nations that I thought it was rather a beautiful symbol, and the way it uses blue. I liked blue as a color, and um, and the Australian delegate, chief delegate to the United Nations, was Dr. H.V. Evatt, who had been a Justice of the High Court of Australia, but had resigned in order to serve in Parliament, and he became Federal Attorney General and Minister for External Affairs. And he would send out to Australia from Lake Success, where the first Secretariat of the United Nations was established, successively the Charter of the United Nations, so that teachers could teach about it, and the Universal Declaration of Human Rights. The Universal Declaration was adopted in December 1948 by the General Assembly of the United Nations. It isn't a treaty, it's a declaration of the United Nations, and it is said to be the most translated publication in the world ever. And it's been was made available to all Australian school children. And we got the Universal Declaration in a little pamphlet. In fact, it wasn't this pamphlet, it was a pamphlet which was oblong, and it was printed on airmail paper, which young people today won't know what airmail paper was. Airmail paper was lightweight paper which you used when you were sending an actual letter overseas, which was the way we had to do it then. And my teachers took me through the Universal Declaration. By the time this had been adopted, I was at the Summerhill Opportunity School, which in the state system was the selective school stream for children who did well in the IQ tests. And so we were streamed off into special schools, and my teacher was Mr. Gorringe. Mr. Gorringe had fought in the Second World War, as many of the teachers had done, and he didn't love war at all, and he didn't glorify war. And he told us that it would be our responsibility as children to pay attention to the Universal Declaration of Human Rights, because it laid down the principles, and unless those principles were observed, then we would just go on having wars. And this was now even more dangerous than it had earlier been because of the nuclear weapons. So that's where I first learned that there was a United Nations organization, um, and the principles of the Charter and the principles of the Universal Declaration, the history of how that had come about, the failure of the League of Nations, and the hopes of the United Nations. And essentially, I'm a product of the idealism of that time. And I still think what Mr. Gorringe taught me was right. Unless we can observe the Charter and observe the principles of the Universal Declaration, we're just going to go on killing each other, and the dangers are enormous, and we have to respond as a rational being to preventing such events. And the Universal Declaration is the sort of roadmap of the basic principles. And it wouldn't be a bad thing if school children in Australia, bereft of their own national Declaration of Human Rights, could be taught these principles, as I was taught, principles which were developed, including by the participation of Dr. Evatt, but in a committee that was chaired by Eleanor Roosevelt, the widow of Franklin Delano Roosevelt, the President of the United States, and a very great woman and a very great fighter for universal human rights.
So we have a lot to thank Mr. Gorringe for, it appears.
Yes, somebody saw that I paid a tribute to him, and his granddaughter. I mean, this is the world of the internet nowadays, and she wrote to me. I didn't know his name, his first name. In those days, you never knew your teacher's first names. Everything was very formal. But she told me his name was Keith Gorringe. So Keith Gorringe is alive in my memory. Teachers don't get paid enough, including university teachers, but they have an impact on a young person's mind that lasts potentially all their lives, and that is the reward, the main reward they get for the gift of teaching.
Well, I'm sure he's extremely proud of you wherever he is, looking back. So we've built this as a session to talk about promoting global human rights through civil society and through UN agencies. And I'm really interested to hear, or we're very interested to hear, what have been your most memorable or challenging experiences working to promote human rights through civil society?
Well, through civil society, it began very early in my career as a law student, and I began being a joiner. And it's very important to be a joiner and not just to be sort of sticking to your mates and staying in your little world. You've got to get out and join civil society organizations. So I joined the Law Society, this Law Student Society, and that led on to the SRC, and I was elected the president of the Sydney SRC, and that led on to the union, and I was elected the president of the union. So naturally, I thought I was going to go on and be president of everything, but it didn't work out that way. But the most memorable civil society experience, I think, was when I was elected to the International Commission of Jurists. And the International Commission of Jurists is the sort of global civil society of jurists. It's a bit different from the International Bar Association, which is like the organized legal profession. The International Commission of Jurists was a bit more elitist, and it selected top lawyers in different countries. Sir Owen Dixon, the then Chief Justice of the High Court of Australia, was the leading proponent of the International Commission of Jurists in Australia. So it was quite a respectable organisation, and it had top judges, barristers, attorneys general, and so on from many countries of the world. I think 50 countries of the world had a member, and I was elected by them as the Australian member. I was then the president of the Court of Appeal of New South Wales. And eventually I went up the ranks and I was elected the president of the ICJ. And there was, you may remember, a big conference in Vienna. I think it was in 1989 or thereabouts. It was the conference where it was decided to establish the office of the High Commissioner for Human Rights. And so it was a sort of watershed moment in the United Nations development of the human rights mechanisms. And so we in the ICJ, the International Commission of Jurists, decided that we would look at our own program and try to see what things we should be doing that would be good for the developing world of human rights. And so I came up with my short list of topics which the ICJ had not been studying and should be studying. And so that list of subjects was privacy protection, because I had been working in the OECD on that subject, and HIV/AIDS, and people living with AIDS and with HIV and the discrimination they suffered. That was on the list. And I gave this list to my colleagues on the management board of the ICJ. And the last one on my list was LGBT rights. And there was a dark silence the minute I raised that subject, because it hadn't been pursued before. And the distinguished commissioner from Ghana, Kofi Kumado, a very distinguished law professor and a brave fighter for human rights in Ghana, said, "Well, I agree with what Kirby has said about AIDS and about issues of technology and the law, but please, we must not have homosexual rights. We don't have any homosexuals in Ghana, and I don't think there are any at all in Africa. And that would be very upsetting if we were to have that topic on our agenda. And I think we can come to that later, but not now, just not now, not ever." And so I was confronted with this. And at that stage, I was really obeying the rule that you don't sort of push this envelope too much. You've got to, I was obeying the rule, don't ask, don't tell. But I thought, no, the time has come to push this. And at home, I had my partner, Johan, who is from the Netherlands, and he is not at all an Anglo-Celtic diplomat. He's in your face. They're very in your face, the people of the Netherlands. And he was browbeating me to be more in your face. And so I thought, yes, we've got to stand up. And so I said, this is a big issue, and I would like the commissioners to rule on it. And so they ultimately did rule on it, and they ruled that we would add LGBT rights to the agenda of the International Commission of Jurists. And it was at about that time that Amnesty International, Human Rights Watch, and other bodies added human sexuality to the agenda of human rights. I didn't do it because they'd done it. I did it because I knew how important it was to me and to others, and I thought it ought to be added, and it was. And it then played a role. I wouldn't exaggerate the role, but with the other bodies, it played the role of putting this onto the agenda of the Human Rights Commission, as it then was, and later of the Council, and now it's a major aspect of the work of universal human rights, even in Ghana. and Ghana still has the old British laws that criminalise homosexual acts, and it's not at all friendly to transgender people or to gays or lesbians or bisexual or other sexual minorities. But things are getting better slowly. But it was put on the agenda as a result of raising it in civil society, and that's how the world changes and how things can change. It takes a long time, but it's got to start somewhere.
Speaking of action that helps the world to change, we're very interested to hear about your current work with the International Bar Association's Human Rights Institute. What are some of the, I guess, the trailblazing initiatives there, and are there any that are taking place in post-conflict situations that we might be able to learn from?
The International Bar Association is the biggest organization of lawyers in the world. It was originally founded in the United States after the Second World War, but it then shifted to London, and it's based in London. And the head of the Secretariat of the IBA on human rights is Baroness Kennedy, Helena Kennedy, who is a member of the House of Lords, and was the head of an Oxford college, and she is a top lawyer, was a top QC, fought in the Irish cases, and so she's got practical day-to-day experience in the law and fighting for human rights, and now she's spending a part of her life working in the Secretariat of mostly volunteers or young lawyers who are working to the agenda which is established by the Council of the Human Rights Institute. I am one of the co-chairs of the Institute. The other co-chair is Anne Ramsberg, who was the registrar of the Bar of Sweden. So she comes from the institutions of the IBA. I come from civil society and experience in the United Nations. Like the United Nations itself, the IBA in this HRI, the Human Rights Institute, spends part of its time working on themes and part of the time working on countries. And the themes that have been addressed include the theme of post-conflict societies and international media, fake news, the protection of journalists in the context of violence in society. And the countries are what you might call the usual suspects. These are countries which step out of line measured by the Universal Declaration of Human Rights. And the role of the ICJ Human Rights Institute is to make representations to support the special rapporteurs that operate in the Human Rights Council, and to write letters of representation to heads of government or heads of state. Last week I wrote a letter to Mr. Duterte, the president of the Philippines, which is a country with very many major problems of violence and cruelty to its people. In recent days, we've been involved in issues of human rights in Hong Kong and in Belarus, in Turkey, and in Malawi, and countries of the Caribbean, El Salvador. And so the task of the co-chairs is to write letters of representation, private at first, but subsequently published. And sometimes these letters of representation can, I think, have a direct impact, as for example, when Malawi, a country with which I had been familiar earlier, had an election, and the election was not considered free and fair, and resulted in the discovery that a very large number of ballots had been altered by Tipex. You may not remember Tipex. Tipex was a fluid that was used early in the days before you got automatic correction of text. What you had to do was put a little bit of this white fluid and then type over it or write over it. And so the then president of Malawi was ready for the election, and when the votes in the election came in and he was not winning, he or his supporters got to work with Tipex. And unfortunately, Tipex is not like a computer alteration, although there you can also have a computer trail that allows you to check what people have done. But Tipex is visible, and the Supreme Court ordered that there be a recount, and that the recount should identify any ballots that were altered by Tipex, and that led to a great uproar, and the president of the time threatened to go ahead with his inauguration, but the Supreme Court transferred the matter to the Constitutional Court, and the Constitutional Court made a decision which upheld the courts below, and the judges of the Constitutional Court came with armed guards protecting them to deliver their decision, but they stood up for the obligation of an integrity in the election, and that was the first time that has happened in Africa. And I'm glad to say that Chatham House, which is another organisation in London that upholds the rule of law, has awarded recognition and awards to all of the judges of the Constitutional Court for their courage and their integrity in upholding the integrity of the election. So the representations don't always have a happy outcome. Many of them are just ignored. In fairness to President Duterte, perhaps because the Philippines still has recollections of the principles of human rights and the rule of law, they always answer and seek to justify what is being done. In other cases, like Belarus, you may not get an answer at all. Kazakhstan always answers the letters. And so we make representations, and we let them know that the world is watching, and that there are people in civil society, in the IBA Human Rights Institute, who will speak up for the principles of the Universal Declaration of Human Rights. So I think Mr. Gorringe would be quite happy that I'm not just thinking about it, I'm doing something about it. And that's the principle behind the International Commission of Jurists, the International Bar Association Human Rights Institute, Amnesty International, and Human Rights Watch. All of these are bodies, mostly comprising lawyers, who are playing a very active part in exploring, studying, and reporting on and making representations about any departures from the principles of the Universal Declaration of Human Rights. It's not just motherhood stuff. It's very much detailed and particular, addressed to treaties which the countries concerned have mostly signed and ratified, but also investigations that have been done which have come to the notice of the IBA or that the IBA has itself taken part in, and those investigations become the basis of the application of the standards of the United Nations in the Universal Declaration and in the international covenants and in the Convention on the Rights of the Child and the CEDAW Treaty and the Disabilities Treaty and the Indigenous Peoples Declaration. So all of these form our basis for action, and civil society prompts the machinery of the United Nations and gives it a very hard time when it doesn't address itself to those issues.
Well, I suspect you may have some letter writing to do to a certain former great power in the near future. I think I have time for one last question before we open the floor to students. And please start populating your questions in the chat function, and I'll call on you to pose those questions directly to Justice Kirby. But I guess my question relates to your work, and you mentioned the Human Rights Special Rapporteurs in Geneva. It relates to your work as Special Rapporteur for Human Rights in Cambodia. And very interested to hear what you see first as what was your greatest challenge there, and second, what was your greatest achievement?
The greatest challenge in Cambodia was to overcome the way in which the UN expected special rapporteurs, or in that case, I was a special representative of the Secretary General, which is a sort of slightly higher level. Boutros Boutros-Ghali had appointed me under the Paris agreements, which terminated the conflict in Cambodia, to be his representative, and my job was to monitor the progress of Cambodia moving from the Khmer Rouge regime through, it was hoped, a democratic election and democratic regime. Unfortunately, things are never as straightforward as you hope and expect. And Cambodia, the first election, which was conducted by Australian peacekeepers and by General Sanderson, an Australian soldier of great integrity, who later became the governor of Western Australia, General Sanderson. He was the head of the Blue Helmets, and he conducted that election, and everyone agreed that that has been the most correct and free and fair election in Cambodia. It resulted in the election of the Fun Sin Pek party. They were the royalist party established originally by Prince Sihanouk, later King Sihanouk of Cambodia. They were sort of a moderate centre-right regime. The other party that had done well in the election was the Cambodian People's Party, led by Hun Sen. Hun Sen is swiftly asserted power and effectively took over. He arrested leaders of the Fun Sin Pek party, including two of the princes who were the children of King Sihanouk. And he is still in power, and he recently arrested the opposition in the legislature So it's a country which from the very start had no real traditions of democracy and human rights, and therefore my job as the special representative was to lay down reports of what had been going on, the good news and the bad news. I insisted on writing my own reports. Now, as informed, that had never been done before. The United Nations methodology had been that officers of the Human Rights Office in the country would do a draft, and the special representative or special rapporteur would graciously review the draft and make a few little changes, and that was how things were done. This is a very Napoleonic system of running the bureaucracy of an organization, and it tends to be the way the United Nations has been organized, influenced by so many European states. But I said, look, I am a professional writer. I was then a justice of the Supreme Court of New South Wales and president of the Court of Appeal. And I said, I want to do this myself. So I would come down towards the end of my mission with a ready-made report. We didn't have computers in this day. This was, we're talking about the 1980s, early 90s. And so I had to print the report very neatly, and then it would be photocopied, and I'd lay it on the table, and then we would discuss it. And they got used to me, and people have said since then that the reason my reports have more bang for the buck and are more direct and express is because I wrote them, and they're not written by a bureaucracy. They're written by a person who knows about human rights and is keen to hold the country concerned to the requirement. There was good news in Cambodia. I ultimately persuaded them to put HIV/AIDS on the agenda, because in Australia I was losing so many friends, gay friends, to the epidemic. To me, this was a very urgent human rights problem, and it was a human rights problem. They were blaming the sex workers from Vietnam, which was ridiculous. It was not factually correct, and therefore we had to get change, and we got change, and that saved lives. Maybe when I come to the pearly gates, the thing in my life that I should be most proud of was shifting the Cambodian strategy on HIV/AIDS to follow what we in Australia were doing, because that helped to save lives of people in Cambodia. I also got them to put Indigenous rights, because disrespect of Indigenous people is not just something white people do. This is something that is true right around the world, and there are Indigenous people who live in the mountains between Cambodia and Vietnam. So they were the good things. The failures really were when it got close to the political government, and dealing with freedom of the press, dealing with respect for the opposition, dealing with respect for human rights principles. In the end, Hun Sen would not speak to me. He relented for a while, and then he wouldn't speak to me. But when I left that office after being appointed to the High Court, my successors all suffered the same fate. Every one of them. They worked for a little while, but when they started to point to defects and criticisms, then the principle of no speaks would be introduced. But the special rapporteur, or later the special representative, had to report those things to the Third Committee of the General Assembly in New York and to the Human Rights Commission, as it was then called, in Geneva. And that itself is a step forward because it imposes accountability, and that is a good thing. So it's not a perfect system, but it is a step in the direction of making tyrants accountable. And that is a step in the right direction for the respect for human rights.
Well, the image of you at the pearly gates will stick with me. I imagine you'll be detained for quite a long time talking about your proudest moments.
Well, I'd have to be very brief because St. Peter or the Almighty has a very strict time limit, like the High Court on special leave applications.
We have quite a lot of, as I'm sure you would have anticipated, we've had a blizzard of questions in the chat.
Well, let's have the questions briefly, and I'll give an answer briefly.
Sure.
So you get a taste of issues.
Terrific. And I've noticed that there's something of a differentiation between some questions which go to pressing issues in post-conflict situations, others that are on other legal issues, and then some others which are about life skills, so, and your insights, your advice. So I think we might start with the ones that are looking at post-conflict situations, and in particular, there are a couple here on the current charges of atrocities by Australian soldiers in Afghanistan. So I think we might start with those. And I might ask Anton, if you could please turn your microphone on and put those questions to Justice Kirby.
Thank you, Jeremy. Good morning, Your Honour. So I'm Anton Churchard. My question is, in relation to the recent ADF inquiry into alleged abuses of Afghanistan nationals under the effective control of ADF SAS soldiers, which revealed the likely unlawful killing of 39 detainees. Whilst these were committed under the law of armed conflict, how damaging will this be for Afghanistan's post-conflict rebuilding process, do you think, and also to Australia's reputation? And the reason I ask is, I used to be in the British Army, and we went through this process in connection with Baha Musa, and I think I felt this type of thing was coming anyway, but now it's come out. It'll be interesting to kind of see what impact, or what you think the impact would be in Afghanistan's reconciliation process, but also the impact on Australia itself.
Well, first of all, the inquiry was not specifically by media. The inquiry was established by the Australian Defence Force, and it was conducted by an force who, in his day job, the Judge of Appeal of the Supreme Court of New Wales, Paul Brereton. That report is now gradually seeping its way in its details into the Australian community. The situation in Afghanistan is very fragile, and the murder of civilians by armed soldiers of competent power is a bad development. On the other hand, we have to say that at least in the case of Australia, it's not swept under the carpet. It has been bubbling along for some time. It was pursued by media, and I think that might have been what you were thinking of a Four Corners program repeatedly pursued it. And the net result of that was the setting up of an independent inquiry, and that was done by a judge who has a commitment. His father was a very fine judge, and also he was also a soldier in the Second World War. So this is a family with commitment to the military, but commitment to the standards of the law of war, and this has come out, and it is a good country that permits these things to be investigated and will then follow up with appropriate disciplinary and criminal action. So I think in the short run, it's going to be very embarrassing. But in the long run, especially because we can't just pick up our bags and go back to a windy, rainy island off the coast of Europe. We're stuck down here in our region, and we have to remain in the long term at peace with our neighbours, and therefore it's going to be important that we not only act justly, but are manifestly seen to act justly and in accordance with the law. Even soldiers are under the discipline of law. So that's my answer to the question.
Thank you. Thank you. We have a couple of questions on your experience in North Korea from Marin and John. I might ask you, John, to pose your question because it has a few more details than Marin's. So John.
Thanks, Jeremy, and good morning, Your Honour. Thank you very much for taking the time to speak with us. In one of our lectures yesterday, we discussed the tremendous difficulty in finding a balance between fostering reconciliation and ensuring prosecution of atrocities in post-conflict societies. Given your experience leading the UN report into North Korean human rights abuses, what do you identify as the most significant challenge to achieving such a balance?
This is the report of the Commission of Inquiry on North Korea. So you'll see it's like a book, and it had to be written in a space of about 4 months, 5 months effectively, to be translated and then presented to the Human Rights Council. The most difficult task of such a report is ensuring that it is followed up. Where there is a country that has allies in the Human Rights Council, in the General Assembly, and in the Security Council that do not want to have issues explored and reported on, they can make it very difficult to achieve outcomes. And that is contrary to what the international community undertook it would do in establishing the United Nations and establishing the international rule of law, in adopting the great treaties and the declaration, and what the United Nations undertook that it would do would be, in the case of very serious crimes, such as genocide, crimes against humanity, and war crimes, it would not turn away. It would not look the other way. It would respond, and it would take action. And if the country concerned didn't do so, then the international community would do so. And this is the problem with the North Korea report. That also was undertaken in a different way from other commissions of inquiry of the Human Rights Commission or Council, because my experience had been as a judge in an English-speaking country who do inquiries in a very transparent manner. Think of the Child Abuse Royal Commission or the Banking Royal Commission. We let it all hang out, and that's part of the process of inquiry. And that's what we did in the North Korea inquiry, and I think that led to a very strong feeling that there shouldn't be a turning away, but there should be action. Now, last week, the Special Rapporteur on North Korea delivered his report to the Human Rights Council, and the Human Rights Council reported to the General Assembly, and the General Assembly adopted a resolution on North Korea. As I looked at the deliberations, it seemed as if nothing had changed since the time we delivered our report in 2014. A number of states came forward and condemned North Korea and supported the supported the COI report and the recommendation that the Security Council should refer the case of North Korea to the International Criminal Court. North Korea is not a party to the Rome Statute that sets up the International Criminal Court, but there is a let-out provision in the Rome Statute that provides that if the Security Council refers the matter, then even though the country concerned is not a party to the Rome Statute, the issue will be referred to the ICC, the International Criminal Court. But that can't happen if one of the permanent 5 members of the Security Council vetoes the referral. And so far, it's been made clear that China and the Russian Federation would veto the referral of DPRK, North Korea, to the International Criminal Court. The hope must be that with the change of administration in the United States and the re-entry of the United States into meaningful engagement with the North Korea situation, that there will be negotiations in the Security Council. Mr. Trump formed a kind of strange admiration society with Kim Jong-un, and he seemed to not want to take further the report of the Commission of Inquiry. But Mr. Biden has announced the name of his intended Secretary of State, and the nominated official is someone who has been extremely critical, according to the internet, of President Trump's approach. So we've just got to watch this space and see what happens. It's a strange thing. I sat in the Security Council when our report was on the table of the Security Council, which itself was a very unusual step for the Security Council to get involved in a human rights report. But when you sit there in this room with the horseshoe table, the great Gobelin tapestries of humanity on the wall, you realize that these 15 human beings sitting around the table have ultimate responsibility for following up on the most difficult problems, including those that endanger peace and security and fundamental human rights. The fact is that the Security Council twice increased the sanctions on North Korea. That meant that Russia and China did not vote against that increased sanctions. So propinquity and the sense of responsibility sometimes works. And we don't know what is going to happen under the Biden administration, but my hope is that people will go back to the report of the inquiry by the Commission of Inquiry, and that the Security Council will get involved, and that sanctions will be imposed and increased, because that's the only language that North Korea seems to understand.
Absolutely, absolutely. Well, we have quite a few questions that we're not going to get to. What I think I might do is ask 3 people to ask their questions, and then Justice Kirby, if you could respond as you see, yes, appropriate or whatever fits in the time. I just think it's important.
It's very hard to deal with complicated matters very briefly, but I will try.
Well, if anyone can, you can. So I might ask the three people that I've identified are Cobra. So I'll ask you to ask your question first, and then Eve, and then Marina. So let's get your questions out, and then we'll give Michael Kirby the rest of the time to respond. So Cobra.
Thank you, Jeremy. Thank you, Honourable Michael Kirby. I just had a question regarding the investigations on Afghanistan. The government decided to establish an independent investigative body to investigate what has the allegations regarding Afghanistan. Do you think that it will actually result in prosecutions, or do you think it's just an administrative step or more like a public diplomacy tactic? Because the UK had also investigated their soldiers in Iraq as well as in Afghanistan, and their investigations on Afghanistan ended, the UK's investigation on Afghanistan ended in 2020 without bringing any charges against any of their soldiers, and they passed a bill in order to protect their soldiers against any prosecution. I was wondering what your thoughts were on whether the investigations in Australia will actually lead to prosecution and trials. Thank you.
Is this, do you say that this happened in the United Kingdom?
Apologies. The UK also started an investigation investigating their own forces.
What is the country that you are suggesting is in default?
But there are allegations that both countries have committed crimes.
Both countries.
At the United Kingdom and Australia. I was wondering whether you think, because Australia decided to create a specific body to investigate these crimes recently. I was wondering whether you think whether the decision to establish that particular unit was whether that body will remain independent from political interference and actually will try to investigate, and if those investigations are substantiated, to bring trials and prosecutions.
Well, I think if they appoint judges in Australia, whether or not they've got honorific appointments to the Australian Defence Force or not, they will get honest reports. I mean, we're like the Malawi judges in that sense. We just tell it as it is, and that is the tradition and the strong self-regard and self-respect that exists in our judiciary. So if your question is, will the truth come out, then the answer is, if they appoint purely internal inspectors who are members of the military and not independent judges, then it might be doubtful. Though Justice Brereton has set a very appropriate and high standard. But if it goes to judicial officers, particularly serving judicial officers, they will just do their duty and tell it correctly. And that is what we would expect, and that is our tradition. I mean, you may know from my opinions in the High Court of Australia, I didn't always agree with my colleagues, but I never doubted their integrity according to their understanding of the law and of the principles. That is what we were all proud of in the Australian judicial system, and what young lawyers have to be proud of and supportive of. So if it's done by judges, the truth will come out.
Thank you.
Well, noting the time, I'm afraid we won't have the opportunity to put those other questions to you, but there were some terrific questions, largely around some of the sort of advice you would give to those who are seeking to go on and do the sorts of things you've done, and also just some very sort of interesting questions, such as what books should we read in our lifetime. So I'll just leave.
You might send those to me, and I'll see if I can answer some of them quickly.
Okay, sure, we'll do that. You don't mean now? I'm assuming you mean later. Yes. And to close, I'd like to thank you so much for an absolutely wonderful session. I'd like to hand back to the person who opened our session so profoundly, Auntie Malara, to give the vote of thanks.
Thank you.
On behalf of my ancestors, the great ancestors of this land, the ancestors who are represented by everybody here, we thank you, we honour you, we bless you for the tremendous leadership that you have shown in all forms of law, the justice you hold up for our law, the Indigenous law, for the great friendship that you have made with all peoples of the world. In your leadership and your humility, your strength and your guidance, your encouragement of all peoples, great and small, is truly a remarkable feat of human leadership. I thank you. My ancestors thank you. The ancestors of all those present thank you. May you be blessed for the rest of your life, and that we are all blessed as well to be in the light of such greatness. Truly humble. Nanga, which means like namaste in our language. Nanga, nanga, nanga.
Thank you, Auntie Malara, and I finish by paying my respects to the Indigenous people of Australia and the many wrongs that have been done by the law, and our duty as lawyers to respond and to correct the injustices and to give them a voice to our federal parliament as they requested at